opportunity to provide information about tools in our Capacity Toolkit. My name is Jen Crane. I'm a trust and estates attorney practicing with Odin Feldman Pittleman in Reston, Virginia. My subspecialties are elder law and special needs, two practice areas near and dear to my heart for the last 17 years. We previously recorded a webinar on this very topic, much greater in length, that is available in the ARC's archives. Our session today was initially planned for an hour and a half. I apologize due to some unforeseen traffic on 95. My day got crunched a little bit. And so I'm going to have to cut things a bit short with the understanding that I will also put my contact information in the chat. So if you have follow-up questions that we don't have an opportunity to discuss, you're most welcome to reach out to me. I'd also ask that as you have questions, you post them in the chat. The beauty of having a smaller group like this is that we have the opportunity to address things that are important to you, subjects that you may want to hear about that I may not have planned to talk about, but there's no reason I can't pivot. Now, my malpractice carrier would be upset with me if I didn't state that this is an educational seminar. It does not constitute an attorney-client relationship. This isn't giving of legal advice. This is an opportunity to offer educational tools about things that families who have an individual with special needs need to know. So I will highly encourage you to post questions. I've got the chat up and open in case anything is posted, and let's go from there. So when we talk about tools in the Capacity Toolkit, what are we talking about? Well, we like to keep things as confusing as possible in this area of law. And throughout our time this morning, truncated though it may be, you are going to see me using two hands. And I do that intentionally because I like to bifurcate things in a way that makes sense. When we talk about capacity, there's legal capacity and medical capacity. Our conversation today is going to focus on legal capacity, not medical capacity. Legal capacity, plainly put, is the ability to understand what it is you're signing, what it is you're doing, to make reasoned, rational decisions with the information that's been presented to you. Now, when an individual comes in to execute estate planning documents, and when I say estate planning documents, let's pause and talk about what those are. Powers of attorney for financial decision-making and medical decision-making, last will and testament, and trust. Those are the four cornerstones that every estate plan should have. When we talk about legal capacity, we're talking about the ability to understand the purpose and intent of those documents. Now, because it's Virginia, there's a different standard of capacity for every document. We want to make things as confusing as possible. But the way to break it down in a way that makes sense is, do you understand what you're signing? Now, when we talk about tools in the Capacity Toolkit, we're really focusing on powers of attorney for financial decision-making and medical decision-making. And then conversely, when that capacity is absent, we're talking about the legal proceedings for guardianship and conservatorship. That's the proceeding before a circuit court judge to have someone declared legally incapacitated and a professional decision maker appointed for them. Let's walk through this. Powers of attorney require an individual to be 18 years of age and to be able to understand that they, as the principal, are appointing an agent to make decisions for them, that they can revoke that power at any time that they want, and that that agent stands in their shoes to serve them. Now, when we talk about capacity, it's important to understand we're not talking about understanding every single word that's inside the document. We need to understand the general concept. Now, the standard for a financial power of attorney is pretty high. It's the same as the capacity to enter into a contract. Put more plainly, could the individual walk into a car dealership and purchase the car without being taken advantage of? That's the ability to contract, to enter into an agreement where you give something for the receipt of something. With a power of attorney for finances, We are giving our agent the authority to make all of these financial decisions on our behalf. It's a difficult burden. It is a burden to clear, and not everyone can. But the first most important distinction to draw is that there's no reason not to try. For a lot of individuals who have a special need, there is unfortunately a presupposition that anyone with a special need or a disability, whichever term you're more comfortable with, and you'll hear me use both, there's no legal distinction between them. Some people have a preference, so I try to be fluid and use both. A lot of times there's a presupposition that individuals with disabilities don't have the capacity to execute powers of attorney. That's false. Every individual should be adjudicated on their own merits whether or not they can enter into this power of attorney, whether or not they possess the capacity to do it. And it's really important that we consider that because powers of attorney have a very close relationship to guardianship and conservatorship, that court proceeding that I mentioned to you. With guardianship and conservatorship, we have to show that an individual is incapacitated such that they can't make their own decisions and that there is no least restrictive alternative available. Put more simply, can this person execute powers of attorney? Does this person have powers of attorney? Do the powers of attorney do the job? So let's talk about those three things. First, can the person execute powers of attorney? For some disabilities, it's very, very clear that the person does have capacity. For example, if someone has a physical disability, they will most likely possess mental capacity or legal capacity to execute these documents, assuming there's no other disability at play. For example, a client very near and dear to my heart used to be a heavy equipment operator. A crane fell on his leg. He is now a paraplegic. However, mentally, he is able to attend to all of his activities of daily living. He pays his bills. He is able to do everything any neurotypical person could do. So we don't need a guardianship or conservatorship for him because he was able to execute powers of attorney. Now, unfortunately, not all disabilities or special needs are as clear cut. Conversely, if I have somebody who has Down syndrome, it is unlikely they will have the capacity to execute powers of attorney. But a huge gray area is autism. There are a lot of individuals, depending on where they fall on the spectrum, who will have capacity to execute or who will not. And that's why, in those situations where it's unclear, my first step is advising parents before you even meet with me. Here is a capacity evaluation form. Go meet with your doctor. Bring your child. And for most of us on this call, we have children with special needs. So that's going to be the example I provide. Go meet with your child is about 17 and a half, 18. You're thinking about guardianship. You're not sure if we can do powers of attorney. You've called your local friendly attorney and you want to know, hey, how do we start this process? Well, for folks who want to meet with me, before they even come in the door, I give them a capacity evaluation form and I tell them to bring it to the medical provider their child sees the most frequently. That person will be in the best position to opine as to whether or not the person has capacity. And that form lists out the different levels of capacity for each of the documents. Because just because we can't do some doesn't mean we can't do others. I want that medical determination before I meet with the client. Why? Well, guardianship and conservatorship is a court proceeding, and it's technically an adverse proceeding. Mom and dad are bringing a suit against their child to have that person declared incapacitated. Because it's adversarial, the attorney you meet with has to be very clear about who they represent. If I have met with an individual to talk about them doing powers of attorney, that person becomes my client. I have confidential information about that individual. I I personally don't feel that I can then bring a guardianship or a conservatorship petition against that person because in that instance I would be representing mom and dad. And if there was a contest If perhaps the individual with special needs wanted to fight that proceeding, I would be in a very awkward position because I'd be representing mom and dad, but I had confidential information about their child whom I met with to determine whether or not they could do powers of attorney. So before I even meet with someone, I have that capacity evaluation form completed and returned. If that form comes back that the individual has capacity, I'll sit down with them to talk about powers of attorney. Now, remember I mentioned at the very beginning of our time together that medical capacity and just want to make sure I'm not missing anything. Okay. That medical capacity and legal capacity are two different things. Just because that medical evaluation came back, hey, we do have capacity, doesn't mean I'm going to feel the same way. I'm going to then sit down with the individual, talk about the powers of attorney, see if I feel the individual has capacity. Will they be able to understand just what they are giving to their agent? Will they understand what they can take away from their agent? If those thresholds are crossed, we can do powers of attorney. But then that leads us to our next question. Okay, we've got medical capacity that leads me to have that initial meeting. We've got legal capacity. Sounds good. Will the powers of attorney do the job? That's the next question. Is the person prone to abuse? Is the person vulnerable to being taken advantage of? If they are, powers of attorney may not be your best bet. Why? Well, powers of attorney are permissive documents. They are not mandatory. What I mean by that is a principal, the person who creates the document, can give to their agent, the person they appoint as their decision maker, the authority to make decisions on their behalf. That's great. But it doesn't protect the person from individuals who may want to take advantage of them. We're going to talk more in depth about guardianship and conservatorship, but let's pretend our capacity isn't there. Let's pretend we have to go forward with guardianship and conservatorship. When that proceeding is, we have our hearing and the judge signs off and enters an order removing legal capacity and appointing a guardianship and appointing a guardian and a conservator. Once that order is entered, it is mandatory. The individual is no longer deemed to be legally capacitated. They can't enter into contracts. They can't enter into contracts. Why does that matter? Well, we're seeing a tremendous uptick in fraud against members of the special needs community. Oftentimes, it's not fraudsters who are going to show up on their doorstep and try to take advantage of them. It's folks who will try to get social security numbers, take out credit cards, loans, things of that nature. But sometimes folks will attempt fraud in person and try to get someone to sign a car loan or, credit card application, something like that. With a guardianship order or a conservatorship order, because it's based on that finding of legal incapacity, you get to void that contract because the person never had capacity to enter into it. If your child, 19 years old, is taken advantage of by someone they work with and convinced to take out a car loan, you get to call the institution that holds the loan and say, my son is legally incapacitated. He does not have the capacity to enter into a contract. Your contract is void. Too bad for you. We're out of it. We don't have that protection with powers of attorney. With powers of attorney, if the individual is prone to being taken advantage of, there's no safeguard in place that allows us to avoid any transactions like this that might occur. So you heard me mention that term, least restrictive alternative. When we have a guardianship and conservatorship proceeding, when we go before the court, and again, I promise I'm going to talk about the details, and we offer there is no least restrictive alternative. That means either that no powers of attorney existed before the person lost capacity, that the person does not have capacity to enter into powers of attorney, or that the powers of attorney won't get the job done because of this vulnerability. And it's a really important distinction to draw. We have to make sure to represent the dignity of the person. That's a real big thing for me. We always have to meet people where they're at, and we have to respect their dignity. And that means at least considering powers of attorney. If your child has special needs and you go to a general practitioner, the first for a general practitioner legally, general practitioner attorney, that person is almost automatically going to assume you need guardianship and conservatorship. If you go to an elder law attorney or a special needs attorney, that attorney is going to ask a lot of probing questions about what the capacity looks like for your loved one, because we want to know, hey, are powers of attorney a possibility? And if not, why? Now, I'm going to pause briefly here. I don't see any questions. I want to give you an opportunity to ask any. When we talk about powers of attorney, we're talking about permissive documents where a principal grants an agent financial decision making or medical decision making. That document, because it is permissive and not mandatory, does not have the protections that we would need for an individual who is unduly vulnerable to being taken advantage of. If there is an individual who is prone to, I'm sorry, I got my first question. Are you able to share the evaluation form for capacity with us? Here's why I can't, because we have different forms. We have forms if we're looking for powers of attorney. We have forms if we're looking for guardianship and conservatorship. Because of that, they're two very distinct things, and it's very easy to use the wrong one. Also really important that they only be used at the appropriate time. For example, for powers of attorney, those forms can only be used when the individual, is 18 or older, because that's the age at which we attain legal capacity, where we become adults. And it's important to note that the law presumes us to be capacitated until there is a court proceeding removing our capacity. However, guardianship and conservatorship petitions can be brought at 17 and a half months. So what I would encourage you to do is reach out to your special needs attorney, talk to them about what your concerns are, and ask which avenue they think you should take. It's also really important that your attorney work in conjunction with the medical provider to make sure that the medical provider understands what they're completing. The same way I don't understand the ins and outs of medical capacity, the same way a doctor would, medical professionals don't understand the ins and outs of legal capacity the way that we do. Again, because the standards are different. The standard for a will, for example, is really, really low. In order to enter into a will, you have to have what's called testamentary capacity. You have to know the nature and extent of your bounty at the time you sign it. That means as long as I can recite to you how much money I have, who my husband and 5 children are, at the moment I'm signing, I've got testamentary capacity. The standard for a durable general power of attorney or a trust is much higher. That's the ability to enter into a contract. Will, powers of attorney for finances. Oftentimes, I will get that evaluation back from the doctor saying that the person with special needs has capacity for a power of attorney, but doesn't have capacity for a will. Well, how is it they have the higher standard but not the lower standard? So oftentimes you want that form completed in conjunction with your attorney, your special needs attorney, and with your doctor. You know, the great thing about these presentations is hopefully it gives you food for thought to go back to your special needs attorney and discuss some things you may not have considered. A lot of folks, and I'm taking 2 steps back to talk about the broad picture for a moment, a lot of folks bifurcate their planning. They just do intermittent pieces, but it's a continuum. We always start with estate planning. You need to have a plan in place that leaves your money to your loved one with special needs in a special needs trust, whether that is a third party standalone trust or whether that is a pool special needs trust. A lot of people, they finish that component and then they leave. Well, then we've got to talk about benefits. What benefits is your child eligible for now? What benefits may they be eligible for in the future? Then we talk about capacity. Who's going to make decisions for your child? Even more importantly, when you're not here. And then the last component of that planning is what I call transition planning. I haven't come up with a better name for it. If you think of a better name, please tell me because I don't like the name I've got. But who's going to take care of your child when you're no longer here? We need to make sure the estate planning, the benefits planning, the capacity planning are all done in advance. But then we need to work with a care manager to make sure there's a plan in place for the physical well-being of your child. Where are they going to live? Who's going to take care of their day to day? Who is their legal decision maker? We want to look at that entire continuum. So I always hesitate to give things out piecemeal because it's never just one piece. It's always something that dovetails with something else. It's a piece of a bigger puzzle. New question. I have a special needs trust, power of attorney, medical directive, last will and testament. Do I need to file guardianship for my 17-year-old child with ASD? Well, those documents, I'm not going to share your name just to protect your privacy, but those documents are for you, not for your child. So those are your powers of attorney. Your child also needs a legal decision maker. Now, the very earliest you can do that is 17 and a half to file a guardianship or conservatorship petition if that's the route that you and your attorney decide to go. It could be that you want to explore powers of attorney first. We do our estate planning as parents. My medically complex child, Joe, is 9, 10. He just had a birthday. I'm going to have to start saying the new age. He doesn't have, I've planned for him in case something happens to my husband and I, but Joe doesn't have any planning yet because he's too young. Once he's closer to 17 and a half, we'll start having this exact same conversation. But it's really important that's a great question. Planning for yourselves dovetails with planning for your child, but they're two separate things. They impact one another, but two separate things. So we've talked about our continuum, and thanks to Jan and the ARC of Prince William County, we've got a couple webinars recorded on these very topics, so you can go back and listen to them. We talked about powers of attorney, walked through those. Let's talk about guardianship and conservatorship. Let's say your evaluation came back, there's no capacity. If that evaluation came back that there's no capacity, we need a different evaluation now, because the one required for the court to file a guardianship and conservatorship petition is much lengthier and a lot deeper. So it tracks the Virginia code very, very closely, and it lays out all of the qualifiers that are met to justify the individual not having legal capacity. So when we file a guardianship or conservatorship petition, guardianship is to make personal decisions, conservatorship is to make financial decisions. When we file that petition, it's filed in the circuit court where you live, Prince William County, Fairfax County, Loudoun County. That petition is filed with, so that's the petition is where we lay out all the facts, where we allege that the individual lacks capacity. Then the next step is the exhibit. It has to go with the petition. It's an exhibit filed under seal, that capacity evaluation, the much more intense one. There's some other things that are required. We have to file the Social Security number. It's a whole packet that gets submitted to court. As part of that process, a guardian ad litem is appointed. A guardian ad litem, and this term varies from state to state. A guardian ad litem in Virginia is not the same thing as one in, say, Massachusetts. Or a guardian ad litem for an incapacitated adult is different than a guardian ad litem for a minor child. The guardian ad litem is not the incapacitated persons or the allegedly incapacitated person known as the respondent for purposes of the proceeding. The GAL is not the respondent's attorney. The GAL is the eyes and ears of the court, and their job is to investigate and report back to the court whether or not the person does indeed seem to be incapacitated. Because remember, we have our medical evaluation, but now we're getting an independent evaluation from a guardian ad litem. And do the people who want to be named as guardian and conservator seem to be good choices? So the guardian ad litem meets with everybody, meets with the respondent, personally hands them copies of the pleadings. And in that pleading is a notice that contains a big warning, all caps, large font, that says, okay, respondent, if this petition's granted, here is all the rights you're going to lose. If the respondent wants to fight the proceeding, they do have that right. They do have the right to have an attorney appointed for them to represent them and fight the proceeding. And that's when the petition becomes contested. Uncontested is when no one is fighting it. Contested is when there's a fight, when the person, the alleged incapacitated person, the respondent, doesn't want this or doesn't want the person who is being appointed. And then there's the hearing. Now, if it's become contested, there's going to be a full-blown trial. If it's uncontested, there's going to be a hearing. These hearings typically take about 5 minutes. The judge has all the parties typically come up to the bench, asks if the guardian ad litem has anything to add to their report. Guardian ad litem typically says no. Judge may ask mom or dad 1 or 2 questions, say something to the respondent if the respondent is there. There's no requirement that the respondent attend. It's always a good idea, but there's no requirement. And then the order gets entered. And then the family will go down to the probate division where they qualify. That's where they raise their right hands and swear to do a good job. And they execute paperwork, they execute bond if it's required. There's a lot of requirements that come along with guardianship and conservatorship. The most important thing for me is that just because it's a quick petition and typically pretty easy doesn't mean it's not a big deal. Removing somebody's legal rights is a very big deal. It used to be when I first started practicing way back in 2007, it used to be that you could maintain some rights while losing others. So for most guardianship petitions, we would typically retain the right to vote, even if the individual couldn't vote, even if they couldn't get to the polls, even if they couldn't understand, because it's a big thing to take away somebody's right to vote. A lot of people fought for a long time for everyone to have that right. Now it's all or nothing. You can't piecemeal maintain rights because the thinking is if you don't have the capacity for some, you don't have the capacity for all. So it's really important before walking down the guardianship and conservatorship road to consider what those rights are that we're losing. Now, that doesn't mean that it's not important and it doesn't mean that it's not necessary. It just means we need to give it due consideration. And unfortunately, too often, these petitions are rubber stamped. So there's a lot that goes into a guardianship and conservatorship petition. A couple of you are probably wondering, can I have guardianship without conservatorship? Can I have conservatorship without guardianship? You absolutely can. There's no requirement that you have both. Now, it is important to remember that both guardianship and conservatorship have reporting requirements. Guardianship requires the completion of regular forms. We just had some major changes in the statute, which will also require periodic reportings to the court and potentially status update hearings to make sure the guardianship is moving along as it should. Conservatorship requires regular reporting to the Commissioner of Accounts. The Commissioner of Accounts is a quasi-judicial officer appointed by the circuit court judges in each county to be the eyes and ears of fiduciary management. Fiduciaries are individuals who stand in our stead to serve us. And when those fiduciaries are managing money, frankly speaking, we have to make sure that they are managing the money and not stealing it. So that's done with the filing of an initial inventory and subsequent accountings, where every asset is accounted for down to the penny. I like to joke that the IRS lets you round to the nearest dollar. Not so with the Commissioner of Accounts. You have to account to the penny with what you're doing for what you are doing with the money. Guardianship and conservatorship are not for the faint of heart. And while they are oftentimes needed and very important, we don't want to get them if we don't need to. If I have an individual on the autism spectrum who the doctor tells me is capacitated, whom I meet with and I am confident they are capacitated, and they're not really in a position to be taken advantage of, I want to try powers of attorney first Just because we try powers of attorney doesn't mean we can't go to guardianship and conservatorship if it turns out it wasn't the appropriate course. We have another question. What happens when you are divorced and both parents file for conservatorship or guardianship or powers of attorney? That is a great question and a very, very complicated one. Depends on whether or not the parents are working in sync with one another. I've represented some divorced parents who are able to co-parent in a way that they can serve as co-guardians or co-conservators. With the requirements in Virginia, especially for guardianship and conservatorship, if one parent brings a petition, the other parent will have to be given notice of the petition. So it can't be given, it can't be granted behind one parent's back. Notice is a fancy way of saying the court has to tell you the process is happening. And that petition and certain aspects of it get mailed out to the individuals that the statute says are entitled to notice. In the case of divorced parents, if one parent is bringing the proceeding, the other parent will be entitled to notice. Powers of attorney is a trickier needle to thread. If the individual is over the age of 18, primarily with one parent, it's absolutely possible that that parent could bring the child to an attorney and that attorney could execute powers of attorney or draft powers of attorney for the individual to execute. Worse still, it's possible that parent could run out powers of attorney on LegalZoom, which I really recommend you not do under any circumstances, divorced, married, anything, and have those powers of attorney witnessed or notarized such that they are valid in the Commonwealth of Virginia. So with the guardianship and conservatorship proceedings, there's going to be notice to the other parent. With the powers of attorney, there may not be. Any other questions that I can answer? I'm thrilled we've gotten a couple so far. Any others that I can answer? I've got chat and questions up, which is why you see my eyes darting between the two screens. Okay, so it's important to remember that powers of attorney are definitely the easier road to hoe. If there's capacity, it's much simpler to bring your child, 18 or older, to an attorney to have powers of attorney done. There's no ongoing reporting requirement, and it's simply easier procedurally to get. Conversely, guardianship and conservatorship, when capacity is not present, require the filing of court petitions and then subsequent regular reportings to that same commissioner of accounts in that same county. Now, it's also really, really, really important to remember that when we do powers of attorney, even though they are easier procedurally, just because you've executed them and just because we have capacity doesn't mean it's a surefire gig. Powers of attorney are universally the most challenging documents to get accepted. Let me caveat that financial powers of attorney. Banks and financial institutions simply do not want to take them because they're worried about fraud. They're worried that somebody is going to bring in a bad power of attorney, do something nefarious with an account, and then big bank is going to be on the hook for it. Which is why when we got the Uniform Power of Attorney Act way back over 10 years now, when we got that Uniform Power of Attorney Act, it included this amazing little caveat that said if a lawyer goes to bat for the power of attorney and that power of attorney is not accepted and that power of attorney is validly executed. So if one of my clients has a power of attorney and Big Bank refuses to take it, and I contact Big Bank and I say, Big Bank, I will give you an affidavit that says the power of attorney is still in full force and effect. It has not been revoked. My client was fully capacitated when he or she signed it. You can rely on it. And I'm signing it as the attorney, which means if I'm wrong, you get to come after me because they basically just want to be able to recover against my malpractice insurance. If I give you all of those pieces and you still don't accept it, I get to bring you to court. And all of those costs for bringing you to court are payable by you, Big Bank. Oh, by the way, I bill out at X number, X hundred of dollars per hour. Would you let me know where you'd like me to send my invoice? Generally, that shakes them loose pretty quick. But that's even for folks who are absolutely, neurotypical, who don't have a special need or disability. When there is a known special need or disability and powers of attorney are at play, there is going to be even more hills to climb and potential challenges raised. Because unfortunately, the ignorance about individuals with disabilities or individuals with special needs being able to execute powers of attorney is incredibly high. And that gets back to why I want that doctor evaluation in my file. When I have somebody come to me, say Big Bank comes and says, Child X is on the spectrum. They don't have power, they didn't have capacity to execute a power of attorney. That's where I say, hang on, Big Bank. I've got a doctor evaluation showing they had medical capacity. I met with the individual for 90 minutes, did my own capacity evaluation. I didn't allow mom or dad to be present while I sat down with the client. I also didn't allow them to be present when I went through the terms of the document and when I had the client sign it. So I've checked those boxes. I'm willing to complete that affidavit saying capacity is present, power of attorney is in full force and effect, hasn't been revoked, and you're still not willing to take it. You're not going to find a lot of attorneys who are willing to do all that background work. It's really important to make sure we can vouch for the power of attorney. I can't vouch for the power of attorney unless I know for sure all of those components are present. I'd like to pause and ask if there's any additional questions. My eyes are darting. Okay, I don't see anything additional. So let's go ahead and recap where we are, what we need to think about. When we have an individual in our lives who has special needs, we've got a lot of planning components. We have our estate planning component, which we had a segment on. We have our capacity component, which we've done previously, we're doing again now. We have our benefit component, making sure our child is getting all the entitlement and means tested benefits they are eligible for. Then we have our transition component. Who's going to take care of our child when we're not here? How are we going to make sure that person is supported and cared for? One of those big components is capacity, decision making. What tools do we have in our toolkit? We have powers of attorney, we have guardianship and conservatorship. They are tied to one another by the concept of capacity. If we have capacity, we can first look to powers of attorney. If we also can protect against vulnerability in a meaningful way without having the power of a court order behind it, powers of attorney are going to do the trick for us. Powers of attorney are living documents. They are permissive documents. They need to be updated every few years. They need to be changed. If all of the agents, the principal names, are no longer available, they have died, they don't want to serve, we would need to, I just got a message, you were going to provide your contact information. Absolutely, I will do it right now. Sorry about that. As any good attorney, I can suck all the air out of a room, even a virtual room, and I got so excited about talking, I forgot. There it is. Okay. Hopefully it made it out to everyone. Because it says just to hosts and panelists. I apologize. Oh, let me try that again. Sorry. Technology is clearly not my bag. I need one of my children here to help me. Okay, there we go. I think that did it. When we're talking about powers of attorney, we're crossing that capacity threshold. We are crossing that vulnerability threshold in a way that makes powers of attorney contendable. Powers of attorney may not be the be all end all. They may work for a time. At some point, we may need to go to guardianship and conservatorship. We always have to consider them first because the key component of my guardianship and conservatorship proceeding is telling the court there is no least restrictive alternative available. Judge, we can't use powers of attorney because the person lacks capacity. Judge, we can't use powers of attorney because they are being taken care of, taken advantage of, left, right, and sideways. I need the power of a court order to step in every time this happens and void whatever that contract was to be able to get the individual out of it. But that being said, I don't want to go down that path if I don't need to. I also only want to get what I need. If I can get by with just guardianship because there's no finances that need to be managed, I want to do that. I can't tell you the number of clients who contact me and they'll say, well, we need a medical decision maker for our child with Down syndrome. And I'll say, great, it doesn't sound like we need conservatorship. And they'll say, well, shouldn't we get it anyway, just to have it? Nope. Conservatorship comes with yeoman's, it's yeoman's effort to keep up with the reporting requirements for conservatorship. When we need it, it's important to get it. But if our individual has no assets in their sole name that need to be managed for them, we don't need conservatorship. Now, it's really important to walk through that with an attorney because the code that governs guardianship and conservatorship proceedings makes several exceptions. If you get a brand spanking new attorney who doesn't understand how this section works, they may bring a guardianship and conservatorship proceeding when only guardianship was required because there's certain carved out exceptions. We don't need a conservator if there's a rep payee. For all of you who your child receives Social Security benefits, if you are their rep payee, the Code of Virginia says we don't need a conservatorship to manage Social Security benefits because there's already a rep payee. It's really, really important to make sure those distinctions are drawn. Make sure, the Code of Virginia doesn't do anybody any favors. It's incredibly complicated. So when you sit down with a special needs attorney, ask, are powers of attorney an option? Yes or no? I want to walk through whether or not my child has capacity. Okay, they're not an option. We're going to court. Do we need guardianship and conservatorship? Tell me why we need both. Walk me through the reporting requirements. It's going to be a lifelong obligation. Parenthood is a lifelong obligation. But what drives me batty as a special needs attorney is when a general practitioner gets stuff we don't need, and now mom and dad are on the hook for all this continued reporting. We want what we need. We don't want what we don't. Now, obviously, the subject area is far too complex. I could talk about this for 8 to 10 hours. And as Jan just mentioned, we've already got the long version presentation posted on the website if you'd like the full deal. Really wanted this to be an opportunity for question and answer. So if anyone has any other questions, I invite you to share those with me now. Or if you have something of a personal nature that you don't want to share with everybody, even though I think we're the only ones who can see it, you're absolutely welcome to email me. You've got my email address. Please shoot me an email. I'm happy to point you in the right direction. I will offer this last tidbit of advice. When you're looking for a special needs attorney, when you're looking for an attorney, ask questions, meet with at least 3. And when I say meet with, call them on the phone. If they're not willing to talk to you for free for 10 to 15 minutes, they're not going to talk to you for free for an hour. But if they're not willing to talk for free for 10 to 15 minutes to see if it's a good fit, you don't want that lawyer. You want somebody who's willing to hear you, make sure it's a good fit, because special needs planning is an incredibly intimate area of law. You have to feel comfortable with the person that you're working with. That 10 to 15-minute interview period will really help you determine whether or not this is a good fit. Haven't seen any other questions come in. As Jan mentioned, we've got tools in the Capacity Toolkit posted on the YouTube channel for the ARC of Greater Prince William. I invite you to reach out by email with any questions. Other than that, Jan, I'll turn it back to you.
Thank you, Jen. It is on our website, as I said, and it's on our YouTube channel. I put that information in the chat. If you go to our website at arcgpw.org, go to events, look under events, there's a Circle of Support conference page, and we have a pre-recorded workshop on tools in the Capacity Toolkit there. It's just a longer version of what Jen did today. Thank you, Jen. If there is more interest, we can arrange for a longer presentation. Just email me. I had that in the chat also at jrussell@arcgpw.org. Eleanor, do you have anything to add?
I'm good. Thank you so much. That was so informative. That was really helpful. Thank you.
My
You
pleasure.
really break it down. Yeah, you really break it down well. So we all appreciate that. I hope to see, we're doing another workshop December 6th. That one's in person on turning 18 in Virginia, what you need to know. So it will go into different things than Jen necessarily might do. Jen, thank you, thank you, thank you.
My
Take
pleasure.
care.
It's an honor to be here. Thanks, everybody. Have a
Okay,
good one. Bye-bye.
bye.